The Red Cross and Red Crescent movement is structured into three components: the International Committee of the Red Cross, the International Federation of Red Cross and Red Crescent Societies, IFRC, and the 191 national societies. Together, they form one unified movement bound by common principles. The International Committee of the Red Cross and Red Crescent works to uphold international humanitarian law and bear witness to the behaviors of parties involved in armed conflicts. The International Federation of the Red Cross and Red Crescent works to coordinate disaster relief work of the national societies in responding to humanitarian disasters around the world. This unique structure allows local societies to respond to national emergencies while drawing strength and legitimacy from a global humanitarian movement.
During the American Civil War, Abraham Lincoln became concerned that Union armies were applying different rules for the treatment of prisoners, civilians, and fugitive slaves. To address this, he asked his Chief of Staff, Henry Halleck, to find someone capable of creating a clear code of conduct for Union forces in the field. Halleck turned to the scholar Francis Lieber. Lieber had experienced war firsthand. As a young Prussian soldier during the Waterloo campaign, he was wounded, abandoned, robbed, and left for dead on the battlefield. He survived, but the brutality of war shaped him for the rest of his life. In 1863, Lieber authored a code of nearly 200 rules governing how Union soldiers were to fight and how they were to treat civilians and prisoners. Known as the Lieber Code, it was the first comprehensive attempt to place humanitarian limits on warfare and later influenced international treaties written in The Hague. The ideas first captured in the Lieber Code did not end with the Civil War. They evolved over time into the Geneva Conventions, which today form the core legal protections for wounded soldiers, prisoners of war, and civilians in armed conflict.
The Geneva Convention of 1864 was the first international treaty to protect wounded soldiers on the battlefield. It required armies to care for the wounded regardless of nationality and established the Red Cross emblem as a protective sign. The treaty was originally signed by 12 nations, but this number quickly expanded to include most of the nations on the earth. At the urging of Clara Barton and the American Red Cross, the United States signed the treaty in 1882. The Hague Conventions of 1899 and 1907 expanded the rules of war into 18 separate treaties. Partly based on the Lieber Code established by Abraham Lincoln during the American Civil War, the treaties codified centuries of customary law and addressed weapons, the treatment of prisoners, and the responsibilities of occupying powers. A famous Hague rule is the prohibition of dum-dum bullets, designed to expand on impact and cause unnecessary suffering. That ban, created in 1899, still applies today, demonstrating how old agreements remain relevant in regulating modern warfare. World War II exposed just how inadequate existing laws were. Over 45 million civilians died, alongside more than 20 million soldiers and 5 million prisoners of war. The scale of suffering highlighted the urgent need for stronger, clearer protections under international law. The Holocaust, the bombing of civilian cities, and the mistreatment of prisoners all underscored the absence of enforceable protections. These tragedies directly inspired the drafting of the 1949 Geneva Conventions, proving that law often advances only after deep human loss. The First Geneva Convention protects the wounded and sick of armed forces on the battlefield, along with the medical personnel and facilities that care for them. It requires humane treatment without distinction and recognition of protective emblems. This means that a medic wearing a Red Cross armband or an ambulance marked with the emblem should never be attacked. Violating this rule endangers humanitarian responders everywhere and undermines the ability to save lives. The Second Geneva Convention extends protections to the wounded, sick, and shipwrecked members of armed forces at sea. It requires that they be collected and cared for, and it shields hospital ships and coastal rescue craft. For example, during naval conflicts, a marked hospital ship cannot be lawfully attacked. This ensures that even in the chaos of maritime warfare, humanitarian obligations are respected. The Third Geneva Convention governs the treatment of prisoners of war. It requires humane treatment, protection from violence, and access to due process. Prisoners must be housed, fed, and allowed correspondence with their families. Access to POW camps by the International Committee of the Red Cross is one of the most visible aspects of this convention. It ensures that even captured combatants retain dignity and basic rights. The Fourth Geneva Convention protects civilians, especially under military occupation. It prohibits collective punishment, ensures essential services, and safeguards hospitals, schools, and religious sites. This convention is especially relevant today in conflicts where military occupation of civilian areas occurs. Its rules prohibit forced population transfers and the settlement of the occupier's citizens in occupied territory, issues that remain at the heart of international disputes. Additional Protocol 1 strengthens protections in international armed conflicts. It reinforces the principles of distinction, proportionality, and precautions in attack. It also expands safeguards for civilians and the natural environment, and clarifies obligations to verify targets and avoid unnecessary harm. This protocol updates and incorporates much of the treaty law established in The Hague at the start of the 20th century. For example, the protocol requires that when launching an attack, commanders must choose methods that minimize incidental civilian damage. This means selecting smaller, more precise munitions, or timing attacks to avoid crowded areas, obligations that make the principles of IHL more concrete in practice. Additional Protocol 2 was groundbreaking because it applied humanitarian law to non-international armed conflicts, such as civil wars. It established minimum protections for persons not participating in hostilities, including prohibitions on violence to life, cruel treatment, and hostage-taking. This protocol came about in part because of conflicts like the Spanish Civil War and later Vietnam, which revealed the need for rules even when wars were fought within states. Today, it is central to addressing humanitarian crises in places like Syria, Myanmar, and Sudan. Additional Protocol 3 codifies the use of the red crystal as a protective emblem, alongside the Red Cross and Red Crescent. The red crystal was created as a neutral, non-religious, and non-political symbol to ensure protection in all contexts. Although it is not currently used by Iran, the red lion and sun emblem from Iran remain an official emblem of the Red Cross movement. The Rome Statute, adopted in 1998, established the International Criminal Court. This permanent court has jurisdiction to prosecute individuals, not states, for the most serious crimes under international law: genocide, crimes against humanity, war crimes, and, with later amendments, the crime of aggression. The ICC represents a major step in holding individuals accountable, even leaders, for violations of international humanitarian law. The creation of the ICC was a milestone in international justice. For example, Thomas Lubanga of the Democratic Republic of Congo was the first person convicted by the ICC, found guilty of conscripting child soldiers. Cases like his show how the court can give voice to victims and signal that such crimes will not go unpunished. Despite having over 100 signatories around the world, a group of very powerful nations do not recognize the jurisdiction of this court over its citizens. The original Geneva Conventions were designed to be enforced by nations against their own citizens, rather than having a supranational body preside over all people. The crimes under ICC jurisdiction are genocide, crimes against humanity, war crimes, and the crime of aggression. Each of these categories reflects the gravest offenses against humanity. Genocide is the intent to destroy in whole or in part a national, ethnic, racial, or religious group. Crimes against humanity include widespread or systematic attacks on civilians. War crimes are serious violations of the laws of war. The crime of aggression involves the use of armed force by one state against another in violation of the UN Charter. The trials of leaders such as Slobodan Milosevic and Charles Taylor, though some were under other tribunals, illustrate the principle behind the ICC, that even the highest-ranking officials can be held accountable for crimes that shock the conscience of humanity. These prosecutions send a message that impunity is no longer acceptable. There are 4 fundamental principles of international humanitarian law governing how wars should be fought. These principles were derived from centuries of customary international law. They were first codified by Francis Lieber in the Lieber Code of 1863, and then incorporated into the many Hague Treaties and Additional Protocol 1 of the Geneva Conventions. We will spend some time with each of these principles and see the important role they play in limiting the devastation caused by war. The principle of military necessity allows only those measures that are required to achieve a legitimate military objective. It does not justify unlimited force, and it never overrides other rules of international humanitarian law. Necessity is about striking what is militarily relevant, not destroying for destruction's sake. For example, a commander may lawfully target an enemy ammunition depot, but necessity does not permit destroying a village that has no military value. This principle ensures that force is tied directly to legitimate objectives, not convenience or revenge.